They were married under the civil code, but did the sale of their land after the family code make the sale of land invalid? Let us see the answer in the case of decided by the Supreme Court decision entitled Alexander v. Escalona, GR number 256141, July 19, 2022.
This is the 16th of the 160 cases decided by Associate Justice Mario Lopez, 2024 Philippine Bar Examination. Subscribe for more.
Facts of the case. Jorge Escalona and Hilaria Escalona were married on November 14, 1960 under the Civil Code. They acquired 2 parcels of land, lot numbers 1 and 2, during their marriage. On June 16, 1998, Jorge waived his rights over lot number 1 in favor of his illegitimate son REYGAN Escalona, without the consent of his wife Hilaria. On July 28, 2005, REYGAN relinquished his rights over lot number 1 to Belinda Alexander. On August 8, 2005, REYGAN also transferred lot number 2 to Belinda. Lastly, on August 10, 2005, REYGAN executed a deed of absolute sale covering lot numbers 1 and 2 in favor of Belinda for P1.6 million. On September 5, 2005, spouses Escalona filed a complaint for annulment of the documents against Belinda and REYGAN. They claimed that Hilaria did not consent to the waiver over lot number 1 and that they never transferred lot number 2 to anyone. The RTC dismissed the complaint on the ground of prescription. However, the CA reversed and nullified the transactions, holding that the sale of conjugal property without the wife's consent is void under the family code. Issue of the case. Whether the sale of conjugal property without the wife's consent is merely voidable or void if the spouses were married during the effectivity of the civil code but the questioned transaction occurred after the family code took effect.
Ruling of the case. The SC held that the sale is void under Article 124 of the Family Code since the transaction happened in 1998, after the effectivity of the Family Code in 1988. The Escalona spouses did not acquire any vested right over the properties before 1988. Hence, Article 124, which requires the consent of both spouses, applies. The sale without the wife's consent is void.
Doctrines of the case. Date of alienation of conjugal property determines applicable law, not date of marriage. Sale without consent under civil code is voidable. Under family code is void. Family code has retroactive effect if no vested rights are impaired. Buyer who relied on void deed is not in good faith.